All right, we will go on the record in the matter 23 FA 35 in re the marriage of Anita Gregelko versus William Daniels. We're set today in this matter for two reasons. One is on order to show cause contempt, as well as another for a request for petition from Mr. Daniels as it relates to the property and his personal property, and I believe the shed that is on the former marital home. So I have both of these in front of me. The order to show cause was filed after, and we have Mr. Daniels' motion that was filed first. So Mr. Daniels, you're going to proceed first, and you have the burden on your matter. Ms. Gregelko, you have the burden on your matter. I'm going to have both of you please stand up, raise your right hand, be sworn in.
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
I do.
All right, do you have any witnesses, either of you?
Nope.
No, it's just both of you? Okay. All right, so Mr. Daniels, you may begin as it relates to your matter.
My matter is pretty simple. Since I was removed from the household, I was never allowed to go back and get
Please put the microphone a little bit closer to you.
There you go. Better. Since I was removed from the house, I was never allowed to go back and get anything, clothes, anything of that nature. And that's why I put the motion in to go retrieve some of my property. And it's been, I don't know how long now.
You win?
Well, I just like the chance to go get it.
A, no idea what you're talking about. B, you have to prove to me that you've attempted to try and.
I've contacted the sheriff's office because I heard they escort you there. But then they wouldn't do it. They said it's now a civil matter. You got to take it in front of the court. So here I am.
Okay.
And
I don't know if you have any property. I don't know what you're asking for. I know nothing. I'm going to go now to the marital settlement agreement that was kind of crappily done.
Yeah.
You know that because you did it. So I'm going to bring that up because that is the law of the land. It was entered into a court order because you both came and said, we're going to do it. We're going to do it. And the commissioner told you twice, bad idea, bad idea. But then you wanted to plow through because you thought you can do it. So I'm going to look at that because that'll tell me what you are legally entitled to. And then we'll go from there. But I can't just say, okay, you can get your stuff because you're not telling me what stuff you have. So I'm seeing right here from the marital settlement agreement, full agreement signed by the court, property at all, other than the poorly done real estate agreement. So that was not addressed. And you know, your underwear at the time of divorce is half hers. Her underwear, half yours. It's all great, but that's the law unless there's an agreement that specifically says, okay, Mr. Daniels gets the pots, the pans, the table. I have nothing.
that's fine.
So I can't just go, okay, you want your property, you get it, because I don't even know what you're asking for.
But that's fine.
You want nothing.
Nope, don't need nothing. It's all,
Then why are we here?
well, I didn't even have a chance to get a change of clothes when I left. Everything was left there.
So even though the law says, and I know Commissioner went over it with you because he's very thorough, the law says after the date of divorce, what's in your hands is in your hands, what's in your hands is in her, or in her hands is in her hands, unless there's some type of order, which would be inclusive, it would include that marital settlement agreement that says that there's this type of division. We're here, you can just kind of see, otherwise, why are we wasting the court's time? So if you want stuff, you gotta ask me right now, so I can talk to
I
her
put in-
and see.
Documents for the shed.
Yeah, I have a letter, that's
Yeah.
correct, you're asking for a shed. Okay, what else? I don't even know after the divorce, because we're talking about something that was done December 2023. We're going on 2 years.
Yeah, and I haven't been allowed in there since.
Yep, because it's not yours. And so here's
It's
the
not
thing,
mine, but-
2 years. And so I don't know if there's even a change of clothing of yours in the house.
Probably not anymore.
Ms. Craig Ilko, is there any personal property of Mr. Daniels in that home?
Yes.
Okay, I'm gonna get more from you than I'm getting from him. What is in that home that you would be prepared to say, you know what, take it all? You sure can, but you have to get them marked, please. And then show them to Mr. Daniels.
Bring them to me and I'll mark them.
Are they all of the property that you're saying is his? You can have them all marked and they can all be marked as one exhibit.
This is the shed that I want left on the property, because it's got electric.
Okay, I don't, whatever you're saying is not going on the record, so I don't know if you're just talking to her
Okay.
about marking stuff.
That's marking stuff.
He said to mark them all as one exhibit,
oh,
so all of it can go together. Nope, same thing. She said all the photographs go together.
This makes it easier. All right, so first show it to Mr. Daniels.
This is the shed that has the electricity into it.
You don't have to explain to it. Just give them to him, let him see it.
Set your tape, and here's your couch and stuff.
All right, you don't, again, don't have to talk to him. Show him, put them back up in your hands and then bring them to me. All he needs to do is see them. Thank you. Now, what are you trying to have me see with these pictures?
The couch is- Nobody's.
Don't care who sits on it. I don't care who doesn't. If you're saying it's his, boom.
The entertainment.
Again, I don't need the commentary.
And then.
Okay. Unless you're arguing and you're saying, I believe I deserve the shed is mine, I don't care that there's electricity.
Okay.
So,
I believe.
all right, so what else is his in the home? Nothing else that you can think of in the shed that I have here?
Clothes and tools. Otherwise, he has. Has a phone.
And so he has a TV?
Yep.
Any dishes? Okay, how long would it take you to go through your house and take all kinds of boxes and pack it all up nicely, not damaging anything? How long will it take you to go through the entire house and say, this looks like it was Mr. Daniels, and throw it in boxes? Only a half a day?
Yeah, there's not that.
All right. Okay, now, Mr. Daniels, as it relates to the shed, she is contesting that that is your property. I do have your petition, your letter petition, so I have what you say in there, but that's not evidence. So now you tell me why you believe the shed is yours and why it should be ordered to you.
Well, I made all the payments on the shed. I put the electricity in. I'm the one who purchased it.
So that was after the divorce?
That was before the divorce.
Okay, so before the divorce, you're all happily married, even if you weren't. And all the money that you spend and all the money that she spends, all of the stuff goes to the property. And so it's called marital property.
We had an arrangement where certain bills were ours and certain bills were theirs.
Doesn't matter.
I know, but that's just what I'm saying.
Okay, so now tell me, as of the date of divorce and what the agreement was, the date of divorce. Because I know, but you need to tell me on the record.
You know, we had spoken before where once it was, you could have the house and I would take the shed and build and live in that. That was the only conversation we had about the shed, to where I could have some place to stay.
Okay, well. To go to the marital settlement agreement. All right, well, there's nothing that said shed in particular as it relates to the marital settlement agreement or the shed when we came back in April of this year as it related to the issue of kind of sorting through the terrible marital settlement agreement. So the court at that time in April of 2025 ordered that the home can be refinanced and purchased by Ms. Gregelko. I don't believe that the shed was addressed. The shed, or what you're referring to as the shed in the marital settlement agreement, is called a bunker, or it was called a bunkhouse. You would build a bunkhouse down the hill. So I have bunkhouse down below the hill, and that's where you were going to reside if you two were still getting along. Obviously, you weren't getting along, and that's why we needed the April matter. And so now we're here. So explain to me, define bunkhouse.
Well, it's just a place where I could reside, someplace either I could fix up or
I get,
build.
I get a definition of what a bunkhouse is. Why are you telling me that the shed is the bunkhouse?
Well, I was planning on just starting with that, so since it's cheaper, it's already built, and I can just add on.
Describe the shed to me.
It's just a 10 by 12 or 10 by 16, forget what size it is. It's got upper level bunks or upper level loss on both ends. It's nothing spectacular. It's just a regular shed you buy like on the side of the street or.
So there's no walls on the inside other than the,
No, I would have to finish it all.
when was the shed purchased in contemplation of the bunkhouse?
I don't know the exact date. The dates were on the payments. I had gave you prior.
When did you give me payments?
I sent, along with that note for the shed, oops, I had a payment schedule sent in also. They had the dates, so I,
It's in teeny language, little font. Oh, I can't really read it when it's microscopic font. What looks like, see, you're making me testify for you. You're supposed to be prepared. You're supposed to have this stuff. You're supposed to have it in front of you. You're supposed to say, hey, judge, I may have given this to you, but I have it right here and I'm going to tell you, I'm going to testify and I'm going to give you this information because when I file it with my motion, it's not evident.
I made the mistake of giving you my only copy.
And then that gets thrown away because it gets scanned. So when did you purchase it? Around what year?
Best guess would be eight years ago.
So if I said, would you recall it being in or around May 2018? Would that sound correct?
Could.
That's the first date I'm seeing on this invoice. Now, 2018 was when you purchased this. The divorce didn't occur until 2023. So was it always the plan that you would not live in the house and you would live in a bunkhouse?
No,
And why was the shed purchased?
it was purchased just to store stuff in. Because she had an apartment she was living in St. Croix Falls that we had to put all our stuff in when she moved into my residence.
So when it was purchased, there was no intention for you to convert that to a bunkhouse.
Right.
Now, shoot me up to 2023 when you're getting divorced. And I'm not going to have you give me too much. We believed it was our intent, these kinds of things, but you put in marital settlement agreement that William will be building a bunkhouse down below the hill and will reside there sometime in the near future. So now it says that you're going to build a bunkhouse. To me, that doesn't mean that there is an intention to have the shed be the bunkhouse.
It was only an option to add on to that as a building.
Why wasn't that put into your marital settlement
Because I
agreement?
didn't write it that way.
It wasn't written anyway with a shed. It said we'll be building a
Right.
bunkhouse. Doesn't say we'll be adding on to the shed and creating a bunkhouse,
Yeah, when you write it, you don't think of that smaller details all the time.
but the commissioner told you.
Yeah.
I know he did twice. He didn't want to go through with it and go and have this marital settlement agreement be approved. But you said to him, what did you say? Gonna be great. Please do it. Please, please, please.
Right,
So the next time you get divorced, I strongly suggest you don't write your own marital settlement agreement. Either get a lawyer or you hash it out in a court. Because otherwise we're here and I have to decipher what it means. But when I look at a contract, I'm told I have to look at exactly what the words mean and say. I can't interpret and go, they meant shed, they meant they were going to add on to it. Because that's not what you're supposed to do when you are interpreting contractual language. And I'm going to tell you, I wasn't there at the hearing, but my gut tells me that the commissioner strongly tried to discourage this from continuing and having this be in order. Precisely for those reasons. So, all right. Ms. Gregelko, I have heard Mr. Daniels and his perspective on the shed and the bunkhouse. And I obviously did an order as it relates to the house in April of 2025. What's your position as it relates to this shed?
I helped to put,
And don't care about that.
okay. Um, And
Again, don't care about that. Because whether or not it stays in the refinancing determines what I do today. Get it, but he says he needs it and wants it too. So I don't care who needs it or wants it. Right now, I'm trying to determine based upon your marital settlement agreement and where we are here today, whether or not this was supposed to be for Mr. Daniels and his ownership or the marital property. Again, that's not my issue today. He could have paid 1,000% of it and it wouldn't have mattered because you were married.
I don't know.
In the marital settlement agreement, and I'm going to read it again, it says, quote, William will be building a bunkhouse down below the hill and will reside there sometime in the near future or as soon as funds can be saved for said project, end quote.
We talked
What do you mean you talked about it?
about the shed.
What was talked about with the shed? But when you did this marital settlement agreement, prior to the commissioner granting the divorce, you contemplated the shed as the bunkhouse. All right. And that's when all things were hunky-dory in your divorce and you were all gonna get along and there'd be rainbows and butterflies. Okay. All right. I'm gonna guess that the bunkhouse or the shed is not located where the bunkhouse was gonna be, below the hill. But you are admitting that you contemplated the shed as being potential bunkhouse or use.
Yes, we talked.
Now, Mr. Daniels, as the marital settlement agreement and the divorce order does not contain any personal property or anything of that for the court to go along with, you heard the list of items that Ms. Greg-Elko admits are yours. I'm just gonna open it up a little bit to you. Other than those items that were listed, is there anything in particular that you can think of, such as a family heirloom or anything of importance or anything like that in the house that you would like to just ask for today?
The only things without getting a detailed list of everything, so just bag list would be the really personal items like she mentioned, pictures, stuff like that, and tools, set of golf clubs.
And do you have
And,
family photos there,
Yes,
like photo albums?
I don't have, oh, I just have pictures.
So some tools, golf clubs. Other things that you can think of. I'm gonna tell you, this is it.
Yeah, just whatever she deems mine is fine with me. I really don't want anything other than the couple items I listed.
Okay, all right. All right, so now I've heard Mr. Daniels' motion. Now I'm going to listen to your motion. You have a order to show cause and you're asking for contempt. Will not sign title, so cannot finalize closing. You have the deed with you.
No.
Divorce is done.
I know.
So, okay, what I didn't quite understand though is you sent a letter yesterday. Mr. Daniels, did you get a copy of that letter?
No, I tried.
All right, I'm gonna print it for you. I'm not saying that I'm even taking it into consideration since it was filed yesterday. And again, it has the microscopic little language, the font. So you're probably not gonna get to read it because you need a magnifying glass. But I'm gonna print it out for you and you can attempt to read it just like I attempted to read it. So if you want to come up here, the clerk is gonna be printing. Oh my. Yeah, it's teeny tiny. And so you guys can understand, I don't know how you expect people to read teeny tiny language.
I tried phone.
Not a computer.
I don't have.
All right, so now, so you're saying that you have the ability to refinance, you just are held up.
And held up, yep.
So you have all of the bank, the mortgage company, whatever it is, has said, yep, you're good to go. We're gonna let you do this. We just need the deed signed.
Yeah, I was ready for phone. That's the one. Whatever it is. Yeah, yeah,
So that's it. You're just waiting him to sign the deed.
yeah, he won't.
All right, Mr. Daniels, why not?
Yeah, I talked to them, but I've been getting calls from a lot of solicitors. And I thought they were just another one, so I just played along and was like, whatever, you know,
All right,
but I understood. And then I just explained to them that I wasn't gonna sign on that because I still got a court case pending on this and I don't wanna sign away the house when I'm trying to go for property on the house, so.
And that makes sense too.
Yeah.
Wanted to figure it out, wanted to figure out where we are. And I didn't get your request for contempt until August 11th anyway,
And that was,
or, yeah, August 11th.
yeah, and that was the last. That was what they noticed.
So where is this, what closing company? Where is that?
That's in Minnesota.
So he has to drive all the way to Minnesota?
I don't know.
Would have been perfect if he would have had the deed so he could have signed it
Yeah,
today.
they didn't.
Did they say that they have a deed for him to sign?
Yeah, they said
Or you have to get one prepared and he sign it, then you have to get it to them. That's my guess of what has to happen.
that, yeah. My paper.
Have it on here. So I guess it kind of looks like they have a deed for him to sign, a deed already prepared. But I'm not sure how he's supposed to sign it. Okay. All right.
Really hard.
All right. Anything else you want me to know, Ms. Gregelko?
I was just asking.
All right. But again, you just filed that yesterday.
Oh,
The teeny tiny little language
oh,
thing.
that one, yeah.
No, that was yesterday. And then that didn't even give Mr. Daniels any notice to be able to think about any argument with that. Plus, it's a silly argument. It's a silly claim that you want. Here's what, anything else you want to tell me, Mr. Daniels?
There is the contested amount of the 26,000, I believe that's listed.
Well, if
To
you
where
didn't
they
file, if
said-
you didn't put that in your petition, that's,
Well, it was supposed to be brought up from the last one, when I had a lawyer. That you guys said I didn't have proof of any payments.
well, it doesn't matter. I did an order,
Yeah.
so it doesn't matter. The order's
Oh.
done.
All right,
So what the order says is what is gonna happen. She must. It's a $28,500 amount based on the above, the court orders that Ms. Gregelko is the staying party and has the right to seek secure financing to pay off the moving party, Mr. Daniels, the equity amount which was stipulated and agreed to by the parties at the contested hearing in the amount of $28,500. And I don't see that that was amended to anything less than that. So it's $28,500.
oh, all right.
And he's gonna get that check, correct?
Yeah, you would, yes.
Anything else, Mr. Daniels?
No, I'm prepared to sign, but like I said, they have to go through proper channels. I mean, they just can't call me on the phone and pretend to have everything ready to sign for me.
Well, yeah, they need to be able to call you and they need to say, here, we need you to go to
Yeah.
whatever place and we have the deed. Okay, here's my decision, and based upon all that I've heard here today. Again, when you got divorced and you did the 2 or 3 drafts of the marital settlement agreement, the language is very important in a contract. The court must look at the language, at the clear definition of what the language means. And so it made it very difficult as it related to trying to decipher, because I have to read this, and that's what happened in the April hearing. The court issued an order and a decision based upon that information. And then today we have to go again and say, okay, so bunkhouse is what was put into that marital settlement agreement. Now, I understand what a bunkhouse is, but I need to know what the parties understood the bunkhouse to mean and to be. And unfortunately, the marital settlement agreement doesn't have anything as it relates to personal property or anything like that. It doesn't even say, Mr. Daniels can retrieve his personal property and Ms. Geico can have her personal property. It's just pretty much void of any language as it relates to personal property. But that would be unfair. That would be what the court would have to order and follow. But ethically and morally, and knowing these things and knowing that he has family heirlooms and clothing and all of that stuff, that would just kind of be sucky. When we're already dealing with a very sucky situation. So you agreed to give him the couch, the recliner, the pictures, some kind of otter, an entertainment center, his clothes, his pots and pans, his odds and ends, and a TV. And you're going to pack all of that up and get that packed up as soon as you practically can. I'm also going to say, if there are tools, because I know men have tools, and he did leave without anything. I know that because there was that injunction, that restraining order that was entered. So he did not have the ability to go back to his home, to your home, the marital home, to retrieve his property. Men have tools. I know that. Now, being married, are you entitled to some of them? Yes. But for the most part, he should get his tools. And if there's golf clubs, he should get his golf clubs. He should get anything that you know is his that you have no use for. Even if you have a use for it, come on, let's be fair. Because I know that he was the one that drafted the marital settlement agreement, and I know how that came to be. But you got everything he had to move out. I have no authority to do that, to say that, except when you stipulate and say you agree to these things and you agree to those other things. So that personal property needs to be packed up, not damaged. So packed up as gently as you can. As it relates to the shed. Now, if the shed wasn't contemplated between both of you to be the bunkhouse, it'd be pretty easy. It's on the property. It was purchased in 2018. Doesn't matter who paid for it because it was purchased when you were married. It was purchased to have the marital property stored in it. It's by the house. However, during this ill-gotten drafting of the marital settlement agreement, it was contemplated that the shed be the bunkhouse. And because it was contemplated that the shed be the bunkhouse or the main part of the bunkhouse, that's what his deal was in the marital settlement agreement. Your deal was you stay in the house, you get that part, that's your residence, even though you were all going to jointly own that property, but he was going to then build his little man mini house down by the hill. So I do find that based upon the testimony and the evidence, the shed is his. That was contemplated that he had the bunkhouse. You're getting, quite honestly, the bulk of the property, the bulk of the good things in this divorce. Again, if the shed wasn't at all contemplated to be part of it because it's not put in the agreement, it would be a shed on the house, but it was contemplated, and I do believe it was contemplated to do that. However, the shed and or the property is not to be turned over until after you sign the marital, the quit claim deed. They're going to call you. They're going to tell you how to sign it. You got to sign that so she can get refinanced, so she can get you your check, and then you can retrieve the shed and all of your property.
So will she now have to refinance again without the shed
It's not my problem.
to get the deed? Or I just gotta wait for a call from
Just
whoever
Huntington.
it is, yeah.
Wait for a call, go sign the deed. Then she can go through the refinancing. then you'll get paid off. She can move on, you can move on, and hopefully you'll never, ever, ever have to talk to each other again. We'll never have to be in court again. You can both just move on.
Perfect.
So I'm going to say, sign the quitclaim deed no later than 2 weeks from today. I would rather have it be sooner, but I can't control Huntington. So you have 2 weeks to be able to sign it. Well, I'm going to say by August 29th. So it's actually a week and a half. But by August 29th, that quitclaim deed must be signed. She must be able to refinance. If not, the court could find you in contempt. You can not only have thousands and thousands of dollars in fines and fees, but you could sit time in jail. The court could order jail. I know you know this, but that's the warning. So sign that quitclaim deed by August 29th. I don't know how long it'll take to get his check. Hopefully it'll be quick and soon. I can't put 2 weeks on the check, but because that's going to be the company giving you the check.
Right.
However, I'm going to say 2 weeks after verification that he has signed the quitclaim deed. So if you hear from Huntington and they say he signed it on the 22nd, then 2 weeks from that date is your deadline to have all of his stuff packed. And then for you, Mr. Daniels, to make arrangements to come and retrieve it.
How do I make arrangements? Because I'm not allowed on the property.
Am I telling you how to do that right
No,
now?
I'll just ask him.
Yes.
Yeah.
I don't know who you're going to get to haul it, to pick it up, to put it on a trailer. That's for you to figure out. But when you go to retrieve it, your personal property and the shed, law enforcement must go with you. It'll be one trip. It'll be an hour or so. They'll go with you. You can retrieve that, and then you can be on your way. So you're going to have to let law enforcement know, plan this with them. But 2 weeks, she has to have it prepared, and then you have to figure it out. Okay?
The election.
Well, I'm going to say it should be capped because you don't want open electric lines anywhere. So you know how to do that? I'm going to guess you put in the electric yourself. I'm going to guess you're pretty handy. So if you can just cap it or make sure that it's not going to be a danger. It's
It'll
going
be
to safe.
disconnected.
What?
It'll be disconnected.
Yes. So you can go ahead and take care of that. I am going to tell you, though, that if Mr. Daniels can't figure out transportation, I think he should be able to with trailer and help.
The shed, I gotta call a shed company to have them come pick up the shed for me. They got semi-trailer, big
Yeah.
old thing to lift it up there. So they'll have to be scheduled. I'm not sure if their window will fit in the 2 weeks, but
And that's where I'm going with
Yeah.
right now. You're not going to lose your property and lose the shed if you can't get another company or can't get the help to come move it with you. So I'm going to say that you're going to have until October 15th. But after October 15th, if you haven't made arrangements to go get it and you haven't gotten your stuff by then, it'll all be one fell swoop, though. You're going to go get the shed and your stuff the same date and time. If by October 15th, you haven't gotten it, it's converting over to ownership of Ms. Greg Elko. And she can do what she wants with it. You can burn it. I don't care, as long as you get the fire department there and with the permits and all those things. Don't care what you do. It will be yours as of October 15th, even the personal property. But again, I'm going to say it's probably not. You won't go to heaven if you don't give him his pictures and his heirlooms and those kinds of things. Okay? Stop making faces, lady. Okay, not you, the lady behind you. All right, so that's the order of the court. Does everybody understand? Any questions?
Nope.
Any questions? So make sure once you get it arranged with that shed company, you arrange it with law enforcement, and you need to let Ms. Greg Elko know. Are you by electronic filing or you're not?
No.
So is there Your daughter, I can't remember, does she have an injunction with him? She does too.
Mhm.
No, I'm not gonna have her get involved, even though she's 8, she's older, she's an adult. One of the sons, are you still talking with one of the sons? No, no talking with one of the sons. Is there a third party that you both
Nope,
get along with?
nobody.
No. It's not the clerk's job to have to call you and say, hey, they've done this. So what I'm going to do is, here's the deal. As it relates to the injunction and this matter, you're going to text each other. That's going to be permitted by this court order, because you need to, time is of the essence. You need to know exactly when he's going to go sign that quitclaim deed, because not only are you going to talk to Huntington, you're going to message her and you're going to say, I'm going to sign this now, today, on August 20th. It's going to be done. And then you're going to be able to text her and say, I've gotten the shed company. They're coming on August 30th. And that's it though. I don't want any other text. I don't want any derogatory names. I don't want any other comments. And you can text back, okay. And Miss Gregelko, you can be in the home, but you cannot go out of the home when all of this property is being picked up. Okay? You understand? And that's family too. Nobody can be outside. You can be inside. No matter what happens on the outside, you can't come out. That's an issue for court, and there's law enforcement. Okay? You understand? Is that a yes?
Yes.
Okay. Any questions?
No, as far as that goes for when she gets all my stuff packed up, so I can get a U-Haul, come pick it up, one swoop. That goes for that too, texting.
Yes.
Yeah, okay.
Yes, that too. But you should go get your stuff the day the shed company goes and gets the shed. Should just be one time. 2 trucks, one time, because I'm not gonna have law enforcement go 2 separate times.
All right.
Okay?
Yep.
All right, questions? All right, then that's the order of the court. Good luck, and then hopefully you'll never have to see each other again. All right, thank you. We are adjourned.
Judge,
Yes.
should I be drafting an order for you?
I'll draft.
Okay, and then are